Welcome to today's webinar, courtesy of the Kentucky Small Business Development Center in Louisville. Discover no-cost, valuable business services to help you thrive, whether starting your entrepreneurial journey or scaling your existing business. We have the resources and expertise to help you succeed. For more information, please visit our website or text 502-977-5800. Thank you for joining us today. Feel free to use the chat feature to ask questions or engage with our speaker. Let's get started.
Hi, welcome everyone. Welcome to another Toolkit Tuesday. We're glad you guys take some time out of your day to join us. And as always, I'm joined by my good friend and coworker, Janet. How are you today, Janet?
I'm doing great, Dave. I'm doing great. I hope everybody's on dry land right now because we've got some flooding going on, but otherwise doing well. Good to see you.
Yeah. So it is a rainy day in Little Kentucky, and but it is always a good day with some good guests here for Toolkit Tuesday. So again, I'm Dave Eck. I'm the director here at the Louisville Small Business Development Center. Our goal here is to help you look for and find the resources to help fund and run your businesses so you can succeed. So as part of that, every week, oh dear, Serene, we generally try to help find resources for you to and bring them to the toolkit so you can just use these to help your business succeed. So as always, if you wouldn't mind, if you look at the bottom of the screen there, you'll see the toolbar, and at the bottom there's a chat feature. If you hover over that, it should pop right up. And if you wouldn't mind, just type in your name, tell us where you're joining from so I know you're out there. I can see you guys popping in here. And we do that because we've had some issues this morning already, or I have, with the internet going down. And with this current storm, we're kind of getting through. Robert from Louisville, hey, how are you? Yes, there's Mr. Lunt, Ms. Lunt, Craig Miller, Louisville. Got some Louisville folks today. We get people from all over the country and the world sometimes, so it's always fun for me to see. Let's see if we can see everybody kind of popping in. As we go through today, if you have any questions or comments, just put them in the chat there. Everybody kind of knows how to work that now. And we will send you a recording and the slides and everything so you can refer back to what we're going to talk about today as much as you want. Hey, John. John's in Nicholasville, not too far south from here. Well, our guest is a great guest, and this is a really important topic for any small business, and that is protecting your intellectual property and making sure that others, especially internationally, doesn't take advantage of what you've already worked on. And one of our hosts is the University of Kentucky, so we've been able to tap deep into their intellectual base. And I'd like to introduce you to Zach Stacy. He is the Associate Director of the Intellectual Property Development Department of the University of Kentucky, and he's is a great resource. So here's an opportunity for you guys to ask an expert specific questions that you have about your situation. So don't hesitate to ask. So again, just put them in the chat. Zach may answer, during the presentation, or we could hold them to the end, whatever works for you. But this is a great opportunity to really talk to Zach. So Zach, welcome. It's good to see you today.
Awesome. Thanks, dude. I will share my screen here and we can kind of get into it.
Yeah, let's just dive right in. Let's see. Here we go. Oh, we're on presenter.
Screen two. Cool. Can you see it now?
Around. Yeah, there we go. Gotcha.
Awesome. Okay.
Perfect.
Hi, everyone. I'm Zach Stacy, and this is just kind of an overview of IP. I know a lot of you folks maybe have dove much further into this world, or you don't know what IP is in the first place. We'll kind of cover a lot of ground, especially the kind of issues you will face in a small business context, and what you can and can't do maybe yourself, what you should go seek an attorney's help with. That's a hard line. I know a lot of folks who run a small business, you wear many hats. And a lot of times figuring out what you're comfortable doing and what you can and can't do. So we'll try to toe that line and figure it out as we go. Let's skip ahead here. So I work at UK. I am the Associate Director of IP. I am a patent attorney in Barton, Kentucky, and with the USPTO. I handle most of the patent filings for the University of Kentucky. We use a lot of outside counsel as well. But that's basically it. We are the tech transfer wing of the University of Kentucky, as well as broadening our scope to we have an investment wing, we have a partnerships wing now. We do a lot of business development, help startups. We've launched plenty of startups at UK. We meet with university inventors and community inventors as well, and opportunities to collaborate, get funding. And I'm on the IP wing of protecting those assets early on, late, wherever they may be, and finding ways to commercialize inventions, ideas, and businesses. So, without further ado, we'll get into it. So why IP matters to small business. This is kind of the why we're here. Your most valuable business assets may be the ones you can't touch. So that's intangible property is if we go to law school and talk about where IP sits. It's these are assets that obviously are not tangible, but you can do many things. You can do with tangible property. You can get securities on them. You can take out loans and things like that on them. So they have value. IP often exceeds physical equipment in worth. Your brand, your software, and creative work can be among your most valuable business assets. They're often overlooked early on, and often, it's something you should consider up front. And we'll kind of talk through the risk with that. But in that vein, risk reduction, early protection can avert costly legal conflicts, prevent rebranding or lawsuits down the road. Investor appeal, building a brand can boost valuation and build partner confidence, and then build you a competitive moat. You can enforce copying and confusion or unauthorized use. It supports market differentiation and long-term brand positioning. It also just helps you, establish your place in the market as an expert, and makes you have some sort of quality control in your product, your service, or whatever you're putting out in the world. So that's a big thing, and we'll kind of go through the big IP areas, which are patents, copyrights, trademarks, trade secrets, and then there's some kind of soft IP things like domain names and things like that. So not legal advice, got to do this. This presentation is not legal advice. It's generally for educational purposes only. If you have legal questions, obviously you want to consult an attorney. IP strategy depends on specific facts, business goals, and legal context, and nothing here creates an attorney-client relationship. Now that we've gotten through that, we can kind of get into it. So IP at a glance. I kind of touched on this. So we have patents, which is inventions and designs. These kind of work down from most involved to least involved, which is good. Just to note, as someone who runs a business or works in small business, the things that you might feel more comfortable, at least doing the upfront, issue spotting of, is this, can we maybe file on this or protect this, or, find a way to commercialize and make money off this thing. Patents are the most statutorily rigid, and difficult to protect. So, and it's a narrow subset. So, they protect new, useful, and non-obvious inventions, grants the right to exclude others from making, using, or selling the invention. And a patent does not give an owner a right to make, use, or sell the invention. We'll get more in depth in these, but this just helps delineate the big four things. So, we think through these things as, a utility patent for like a brewing mechanism, or any sort of like medical device or a drug, or just any actual tangible thing. We have processes too and ways of making things, but it's what you think of traditionally within the I'm inventing something. How do I protect it and license it out? Trademarks. This is more broadly applicable to those who are not day in and day out making things or inventing things. It's your brand. Protects brand names, logos, slogans that identify the source of goods or services. We'll get more into details on this, but that's a clear, crucial delineation for someone who's new to this. The object of a trademark is to signify the source of the good or service. So if we're getting into the weeds, there's a difference between service marks and trademarks. So delineating between a service and a good. But really you're trying to show the origin that you yourself, that Coke makes this recipe, and that when someone buys something with the Coke name on it, they're getting a Coke product. That's really the crux of it. Rights begin with the use in commerce. So this is something, whereas patents, we don't want to use the invention or put it out in the public until we have protection. Trademarks, you're often incentivized to get adoption and use it. And then a registration mark, we'll get into this, enhances protection. That's through filing with the United States Patent and Trademark Office. And going through that process. That is a legal process set up by statute. Kentucky also has protections for your brand and things like that we'll get into as well at the state level. But trademarks are traditionally discussed at the federal level, and we'll hit both. Copyrights are creative expression. Much broader. There's common law copyright that affixes upon the creation of a fixing of a creative expression into a medium, which happens all the time. We were all creating copyright left and right by writing things, drafting things, coding things, whatever it may be. So it protects original creative works, text, software, art, music, fixed in a tangible form. It's automatic upon creation. Gives exclusive rights to copy, distribute, or adapt. This is something that we're touching and using all the time just by using PowerPoint right now. There's a software license that I had to click to use it. All that's protected by copyright. Trade secrets. This is one that we have expanded at the university because a lot of it, it's more commonly known now as know-how. So it's any sort of confidential information that you have, whether it be formulas, customer lists, algorithms that you can keep secret. No registrations required. No time limit if secrecy is maintained. So really, a lot of this is on the back end through agreements, employment agreements to keep the information from getting out. You have a cause of action if someone misappropriates that information. So think, secret formulas, the herbs and spices at KFC, the formula at Coke, and so on. Client lists within sales businesses or service providers, those could be trade secrets as well. If someone leaves your company, you want to have an agreement where they can't take all your clients or any proprietary information that you have. So yeah, we'll keep on rolling through. And I guess that's something also to highlight with now the adoption of AI. You just want to know where your information is going all the time. But I'm not a data privacy attorney, so I'm not going to get into that. But one product, many IP assets. So any particular thing can kind of touch on all of these. So an example I use all the time is like a branded mobile app. You can trademark the app and the name. Wordle is one I just discussed with someone recently. New York Times owns a trademark to the name Wordle. They have a copyright on the source code and the user interface, the black and white tiles. They could have a patent to the underlying design, not the utility, because software in that case, the idea of using five-letter permutations of words is not patentable. It's abstract. We'll get into that. And then maybe any trade secrets on how they, on the back end, are working those things or getting it out there and things like that. So a lot of times we're using this tangled web of IP protections to protect an asset, and there's a lot of business strategy. And upfront is just identifying what is what and how do you protect it, right? That's a big thing. Big companies obviously have huge legal departments that do this. Apple is famous for building that web of AirPods. I have a pair right here. There's design patents around the beveled edges. There's utility patents on how they actually work. There's copyright on the software. They're licensing copyright for Bluetooth and the trademark to Bluetooth. So we have this tangled web of IP, and as participants in the marketplace, we don't understand how these things work together, and also as providers of services and goods, we need to know how to protect ourselves. So that's the big thing. They're all kind of interwoven here, and there's strategic implications of where you choose to do and what you choose to do. So we're gonna keep on going there. So patents, we'll go a little deeper into patents here. So a patent grants a right to exclude. If you leave here with anything on patents, just know that we have this conversation quite frequently. Just because you file a patent and just because you get a patent granted does not mean you have the right to manufacture, use, sell, make. You do have the right to stop others from making, using, and selling. So it's kind of a negative right. You can sue others to stop making and infringing. But you don't, it does not give you any rights. So you do have to do a clearance search for yourself if you're making a product to see if there's nothing that's covering what you are doing. And that's just a useful delineation. It applies to both utility patents and design patents. So up there on the screen, they're the three big ones. Historically, if you deal with a patent practitioner in Kentucky or anywhere, most of their work will predominantly be utility patents. That's what you usually think of when you think of a patent. It covers a functional invention. And the statute, passed by Congress says process machines, manufactured articles, and compositions of matter. And then we get into when you file a patent application with the USPTO, they will examine it for its usefulness, its novelty, and its non-obviousness. These are the conversations I have day in and day out with inventors at UK. We'll do a search. We'll see if the invention is new, useful, or non-obvious. We try to be nice about it because no one wants to hear that the thing that they spent the last 10 years on is not new. And often we can find the novel aspects and we can differentiate it from the prior art. That's oftentimes what you're paying for an attorney to do. There's a back and forth. It's called patent prosecution with the USPTO. Right now, I just looked at the other day. For most art heirs of the USPTO, it's 21 months to hear back once you file a non-provisional patent application. So it is a long process. From there, you go back and forth with them to argue these aspects, the novelty, the usefulness, the non-obviousness with the USPTO. So it's a process. It's all protected by statute. It's a legal proceeding with the USPTO. And this is something from the non-provisional stage, wouldn't necessarily recommend doing yourself. People have done it and they do it and they use AI now to do it. It's just there's a lot on the line there, and it's there's an art to it, and you only get one bite at the apple, so you don't really want to miss out, especially if it's something that's going to take off. Design patents cover the ornamental design. I get a lot of questions at UK from our College of Design, especially the students, on these, because maybe they know that what they have is not traditionally patentable as far as functionally. Maybe it's how a chair looks or a certain color scheme or anything like that. You can protect that with a design patent. These have 15 years of patent term versus the 20 for utility patents, both of which are from the filing date, not from the issuance. So this is part of the strategy that we have at UK, where we have people publishing all the time in academia. And that's counterintuitive to an IP protection strategy. Traditionally, you want to keep things under wraps as long as possible, because the minute you file that non-provisional application, you start your patent term. So that 20 years starts. It's really big when it comes to medical devices and therapeutics. That area, as you can imagine, and really anything novel that's going to, days and weeks do matter from exclusivity. The government's granting you a monopoly over your invention, and you want to have as long of a runway as possible. So it's all strategy, and these are things you can do as not being an attorney, is strategically managing. Maybe you have an idea, you're trying to prototype it, having confidentiality agreements with the folks who are working on that in your company to prevent that public disclosure as long as possible. Because once you file it, if it's a design patent, you have 15 years. If it's utility patent, you have 20, and that's we'll talk about it, but the novelty bar from making it public also starts that clock. So then the third, much less prevalent, and I'm happy to talk to someone if they have questions about this in the chat, are plant patents. These cover new and distinct varieties of asexually reproduced plants. Not something we address a lot at UK. A lot of universities do. Usually at UK, we're dealing with non-asexually sexually reproduced plants, so we're dealing with mass farming, not on a smaller scale for asexually reproduced plants. But there is a way to protect those with the USPTO. Outside of plant patents, you can register plant varietals with the USDA and other government organizations, but pretty limited. This is a pretty unique subset of attorneys, and I would be out of my lane to really get into details on filing of plant patents. But those are the big three. When someone says a patent, they have a patent. That's kind of the first question: is a utility, is a design, and is it granted, is it pending, things like that. So this kind of goes more into detail. I hit on most of it. The functionality versus the ornamental design. Both of these, you file with the USPTO, you prosecute. You're trying to claim your stake in the ground on what you own, your meets and bounds, the deed around what it is that you own intellectually. But again, this is more of a reference. We'll send these slides out later. Original versus non. So this is a very useful one to know, and these terms are thrown around pretty free and loose for folks who are not aware of how patents work. But so a provisional patent application is really just a placeholder. So in the United States, we switched in 2013 to a first to file jurisdiction. For a long time, it was first to invent. You could file with proceeding with the USPTO to argue with someone on when you came up with the idea first. Now we are similar to how deeds are recorded in some counties with a race notice, but we're a first to the patent office jurisdiction, which helped us align with the rest of the world since these things are international. So a provisional patent application holds your place in line with the USPTO. So it's it's very informal. Oftentimes at UK, we'll file like a scholarly article or even a poster presentation. I mean, I've done things as weak as like something drawn on a napkin and then a write-up in just a quick Microsoft Word document that we've saved as a PDF and thrown in there. Really, all you need to do is describe the invention with enabling detail. Normally for us, we're trying to get these before someone makes something public. If they're going to present it, if they're going to sell it, if they're going to show it to someone outside of confidentiality, we want to make sure we have a provisional patent application at the USPTO, which indicates who the inventor is, when it was invented, and that it's yours. It establishes a chain of custody of sorts. So that's a provisional. These do not grant. They're good for 12 months. Then you have to make a decision on what you're doing. It does establish a patent pending status, which could help you with getting funding, with getting brand recognition and things like that. And they're much cheaper, which we'll get into as well. Filing fees are less than $100, especially for a smaller entity and things like that. So these things, I'm not telling you to do this. You could feel more comfortable doing yourself. Again, I would always recommend getting an attorney. But since these are more informal, it's much easier to kind of figure out how to file with USPTO. Now, problems could pop up down the line if this ever saw a court if you did it yourself, but again, it's far and few between. Again, not legal advice, but there's a much more doable thing. Now, on the much less doable side is the non-provisional patent application. This is the formal application that is examined by the USPTO. There's a lot of requirements and statutory provisions on margins and font size and type of document and words you can use and words you can't use. And this is where you have claims at the end that are argued over in court and things like that. So this is much more nuanced. It takes some white gloves to kind of iron it out. And not, you don't want to just count yourself short, right? If you can do these things and just from practicing and doing this, you learn tricks of the trade that give you broader scope and give you better allowances and you know the right things to say to get the right application. So this is what takes 2 to 3 years to get. You got to pay an issue fee at the end. It's a little more expensive, and this actually gives you enforceable rights in a patent that it can grant. You have a 20-year term. Non-provisionals are an actual asset like anything else. You can take out loans and use it as security. It can come up in divorces and any sort of other proceeding as a actual piece of property. A granted non-provisional application. A pending non-provisional application is kind of treated legally like like an option contract. Like it can issue, it can not. But as far as small business owner goes, just knowing the difference between those two things is pretty helpful. And even if you're dealing with someone and they say I have a patent application, it's helpful to be like, well, oh, is it a provisional? Is it non-provisional? Like it really does kind of tell you where they're at because these two things are pretty vastly different. It's all part of the process, but pretty different. Up top, there's kind of a timeline there. So you get patent pending just on a provisional application for 12 months, and then you file a non-provisional within the 12 months of filing that. And then you have about 2 to 3 years of USP2 examination. That could be much longer. You can pay to expedite it as well. But 2 to 3 years is what we roughly look at in that. And that clock is running from that filing of the non-provisional the entire time. So public disclosure, there's a lot of issues we can talk about for patents for small businesses, and I'm talking quite fast, but we'll hit this big one because this is the one that I have seen firsthand just in my personal life with inventors. I was an engineer before I went to law school. I knew folks are inventing stuff left and right, and now it's easier than ever to make a prototype with a 3D printer and to throw it up on Shopify or Amazon or whatever and get it out there, or give it to friends, anything like that. Anything outside of confidentiality can start a public disclosure bar. So many of you may know you have a year from public disclosure in the United States to file a patent application. After that year, you lose patent rights. Now that is contemplated, and it's funny to go back to the Constitution. I taught engineering class this semester, and all the kids were like, we were talking about the Constitution. What's going on here? But when the founders of the country were talking about a patent system, there was some debate over issuing a monopoly over an invention or an idea. And part of that was the public aspect of you're giving up public knowledge of how to do the thing that you're trying to protect, right? So if people already know how to do the thing, then the government's not going to issue you a private monopoly over the idea. So that's kind of where this comes from. You have a year to file a patent application after making it public to be granted a 20-year monopoly over the idea. And that's hard and fast. That is the rule in the US. And it's honestly more lenient than the rest of the world. So patents are jurisdictional. Oftentimes at UK, we will file what's called a PCT application. It opens up a 30-month window to file in other countries. But the process that I outlined in the US, you do in every country. It's wild. It exponentially increases costs, as you can imagine. And these prosecutions in all these various countries could run in tandem, but they have their own laws. They're roughly the same. We have treaties that do codify these things, but different countries, different jurisdictions have different views on certain aspects of the patenting system. And these things run in tandem, and you could have an issued patent in the US and maybe not get it issued in China and so on. So if you want international coverage, after you file a provisional, you file what's called a PCT application. That'll open that 30-month window to then enter whatever other countries you want to enter. So all that's just part of the timeline management. But a lot of foreign countries have what's called an absolute novelty bar. If anything's made public before filing a patent application, you lose the ability to file in those countries. So something to keep in mind. That's why we file provisionals at UK before we make a public disclosure. That saves your foreign rights because you filed something before a public disclosure. In the US, we give a 1-year grace period. That's not an ideal situation, but it does secure some sort of patent protection for you and your business if that's what you're looking at. So just things to know up front, right? You know, if you make these decisions and you didn't know about this, you know, sadly, just like taxes, ignorance is not a defense. So we gotta stay abreast of these things. You know, easy things to do as a business is to have confidentiality agreements, to have within your employment contracts with your employees, some sort of confidentiality provision, keeping these things protected and doing your best to keep them under wraps as long as possible. Obviously, you got to make money. Obviously, you know, the general public's going to have to see these things. But just knowing that you need to get something filed before that is really the main thing. The one thing I can press upon folks the most is knowing the public disclosure bar. Because there's a lot of good ideas out there that have been lost to this. Now, what happens if you lose this in the United States? Whatever your invention is that was public before, you know, a 1 year has passed, then becomes prior art against whatever you invent in the future. So maybe, you know, you've invented, you know, a new type of watch, and it's public, and, you know, you got to iterate on that design, and it has to be patently distinct upon the watch that you invented over a year ago. It happens, it's possible. It sometimes drives innovation, because now you have to think more creatively to find something that's patently distinct from your actual own invention. But it's a hard bar, especially if what you invented before is novel and is the basis of your business. So there's something to keep in mind. 1 year grace period for novelty, strict novelty standard, not great. Parental considerations. So patents are expensive. Government fees plus attorney costs add up. Plus, then once you get a grant, you have to pay maintenance fees at 7, 11, 4.5, 6, 7.5, 11.5 years with the USPTO. There are discounts for small entities, which are nice. So small and micro any discounts reduce government fees by 60 to 80%, which is great. Which really does help. If you're a nonprofit, you're treated as a small entity. So UK, despite our massive budget, is treated like a small entity with the USPTO because we are a nonprofit. And that would apply to anyone who's a nonprofit. Multi-year timeline takes a while, and then strategic decisions. Like you just gotta stay abreast on your timeline and where and what you want to do, what kind of markets you're looking at. If you're international, just keeping those things in mind long term. And these are things you gotta know maybe even before you've made a sale, or even really have and engage stakeholders. You know, these are things you got to have up front. So, which is tough. You know, at UK, we're able to invest in inventors early who may not have the capital to pay for these things, but I mean, it's expensive costs up front that you got to do early. So it is prohibitive for many folks. Trade secrets, you know, we're gonna hit on these later, but trade secrets are just things that are you know, keeping confidential. No cost. You know, they're harder to assert. You can't really assert them against someone else, but you can assert someone stealing them. I have people ask me all the time, you know, because they don't want to pay for a patent. Can I just have it as a trade secret? Yes, but it affords you far less rights. Indefinite term. One leak ends protection permanently. So if someone, you know, has access or figures it out, or an employee is not under confidentiality or a contractor is not bound to confidentiality and they have access to it, you've lost your trade secret. So they're hard to enforce. It requires some pretty strong institutional procedures, but it is something someone who's savvy can use at least up front to keep things protected, maybe while you're raising capital or getting the funds to actually file a patent application. So trademarks, this is one that's more broadly applicable to small businesses. Okay, cool. Trademarks, really, we can have these in everywhere. So trademarks protect brand identifiers. The rights begin with use in commerce or an intent to use in commerce. In the United States, we have an intent to use standard that you can file. It's a little more expensive, but if you're intending to roll something out or sell something, you can do that. This is actually a legal question that I had early on in my career. Was about when we make merchandise for Kentucky Derby winners. It'd be weird to just start selling shirts for a horse that hasn't won anything yet. So that intent to use standard really does help you in the United States because you can file a trademark for American Pharoah before he's won a horse, before the horse has won a race, and you can protect, you know, someone printing shirts and apparel and all these other things for that. But the other way is just by selling things with the name on it. I can sell Nike shoes, and then I can go register the trademark for Nike athletic shoes with the USPTO. So it provides nationwide constructive notice and stronger legal remedies if you file it federally and get it registered. So what is a trademark? A word, name, logo, slogan, or package design that identifies your product or service source and distinguishes it from competitors. Trademarks can include brand names, stylized logos, color combinations, and distinctive packaging, so trade dress, and any identifier consumers associate with a single source. It's pretty broad. Trademark a lot of things. Trademark jingles, trademark anything that helps signify a brand. The most common one is a word mark. So it's just the actual word itself. Common law rights, simply by using a mark in commerce, you can create a basic trademark right automatically, which allows you to use the TM symbol. So TM you use if you have a common law trademark or you have applied for a trademark. You can use the R as a registered trademark if you get it registered by the USPTO, which in a lot of ways, I mean, not to get too bogged down in legal status of it all, but it does provide a de facto um, signal that A, you have a registered trademark and you've gone through the process and the date and all these things. So it streamlines the process. You send someone a cease and desist and you have a registered trademark, you know, their attorney should tell them to stop doing it. If it's just a TM, maybe, someone would dig a little further. But registration does not extinguish rights of prior users who establish use before registration. So this comes up when there's two brands that are using similar words. You can think of, similar things. There's a Kentucky Cafe Blue Ridge Coffee, that hasn't registered. There's a Virginia chain that registers as a Blue Ridge Coffee. The Virginia chain, even though they're registered after the Kentucky chain, they can't exclude someone who's been using it beforehand. This popped up. There's a Burger King in Illinois that was preceded the registration of Burger King as a trademark. So they're grandfathered in. You can't tell someone to stop using it. So unlike patents where you do have rights to exclude anyone you get a grant a patent on. So you're protected in the trademark sense through use. You have to establish it. You can't just have the idea. And registering is always the easiest way to do that. So trademarks, names, big useful thing for businesses. So business name versus trademark. So registering, this comes up a lot. So we can get a trademark but not have the business name. We can get a business name and not get the trademark. Same goes for domains and social handles. So in 2026, those are just as important or more important. So a common mistake is registering LLC or business name without checking for trademarks and things like that. So state and corporation does not create trademark rights or guarantee you're free to use that name. Just means that no one else has registered that name in the state. And I know many of you have filed business filings with the Secretary of State in Kentucky. They're not really auditing those names against federal registered trademarks. It's a hard thing to do. I mean, usually folks will pay a law firm to do a formal search. But obviously, if you're just starting out, something you can do yourself, you can go to the USPTO, you can search for trademarks within the names you're thinking of and minor permutations. Do it all the time. It's not that difficult once you get the hang of it. Just searching the way you would formally on like Google. And all those resources are free through the USPTO. Another common mistake is owning a domain or social handle. In the reality, a domain name is just an internet address and it does not confer trademark rights or brand ownership. It goes both ways, right? If you have a trademark but not the domain name, it has a lot less value. If you have a domain name but not the trademark, it will inhibit your ability to use it or create a brand around it. So two separate things to keep in mind. And then the third thing, the common mistake on there is assuming name/URL availability means it's safe to use. Yeah, I mean, I can probably get a domain name right now for many things that are trademarked as word marks. Someone can sue me for using their trademark. So just something to keep in mind. Always clear a name independently and check USPTO databases for these things. So yeah, the state also has a registration for these things. You can also do as well. So strong versus weak trademarks. We'll go through this very quickly. And this is more so if you're thinking of a new name. We provide different levels of protection for trademarks, and this is more of a common law thing. It's not gonna say on your trademark registration, this is a fanciful strong mark. You just know if you get sued or you sue someone. So fanciful marks are a coined, invented word with no prior meaning, created solely as a trademark. So Xerox is not a thing. It is just a name for a product that we have now associated, the goods with the name. Kodak is another one of those things. Anything where the name does not signify the actual good. Nike is one of those things as well. Nike does not implicate running shoes. I mean, you can get there, but that's what it is. Arbitrary, a real common word used in an unrelated context. So, apples are the fruit. It's also the music label for the Beatles and also computers. But we know that Apple as a, it's a fruit. It exists in the English language as a thing. So it's arbitrary because it has nothing to do with the music label or computers. So yeah, no connection to the goods or services that are being done there. Suggestive mark hints or implies product quality. We see this a lot. Netflix, an internet streaming system for movies. Descriptive, describes. We see these all the time for services because you also, you're balancing the fact that you want your consumer to know what you are. So like best quality plumbing or, Dave's dry cleaners, whatever it may be, if you're signifying what it is. And then generic, you cannot protect. generic names like coffee shop or anything like that. Now, there's ways if you establish brand recognition that you can then argue that it's not generic, and there's ways that an arbitrary name can become generic. This is called genericide, which is an intense name for what it is. But that's what happened to Kleenex. We refer to tissues now as Kleenexes. You would, if you're a IP attorney or someone running a brand, you would say Kleenex tissues or facial tissues or sanitary wipes. So that is something from Edge to, and again, not legal advice, but if you are creating branding and you're trying to retain a strong mark, you will always use it as an adjective. So, in these contexts, we would say Apple computers, we would say Netflix streaming service, how adjectives are used because we want the name to not signify the noun that is the good because we could lose protection if it then becomes synonymous with the good. So keeping on here, clearing a trademark. Search before you invest. I'll leave this up here. We'll send these out, but things you can do yourself just to quickly get a feel for the industry and what's going on. There may be registered trademarks out there you had no idea because you just don't know the brand, or maybe they didn't really take off. But it's something to do before you start investing heavily into merchandise or building a brand and people having name recognition. Something to do. So copyright's much more broader. We deal with all this time at UK for written works, business plans, teaching, educational materials, books, as well as software. I just had a conversation with someone over. This happens all the time with music, master recordings, written songs, things like that. So copyright protects original creative works, fixed in a tangible medium, automatically upon creation, but not the ideas, facts, or methods. So the statute's original works of authorship fixed in tangible form. That's like pretty broad. Anytime you fix something in a form, so whether that's writing, recording, or a digital file, protection is automatic upon creation. So this is where, agreements are really important when you're hiring folks. Maybe you're filling content or an ad for your business and you just have a buddy who's good with the camera, come and take those pictures. They would probably own those because they're the one fixing it in a medium. So these are things where you want to have agreements in place because copyright protection is pretty fickle. This is the whole Taylor Swift master situation with Big Machine Records and Scooter Braun. If you are a Swiftie, that brought that to the forefront. But there's plenty of other situations where copyright is shared inadvertently because it can be created very, very easily. So that is the fickle thing with copyright. Patent, there's a long process. Trademark, there's a process. Copyright does affix pretty quickly. So you just want to have these things buttoned up before you do it. So before you hire someone to maybe do translation or film content for you, create content for you, you want to have work for hire language in a contract to assign ownership to you, the business. Now, I'll get into these a little bit more. I have some examples there: books, text, software code, photos and graphics, music and audio, and artwork. What's not protected are the underlying ideas, concepts, facts, methods, or systems. Patents do protect the more intellectual, how you do a thing. And then copyright's the actual expression of the thing, right? So a good example of this is, like this iPhone, iMessage. There are protections through design patents and things like that for the blue texts that are in the iMessage. But the underlying code written to send the blue text is copyright. If I wanted to write a code to send messages, the idea of sending blue messages is not protected. The actual specific look of the blue messages is very narrowly protected. And also the actual word for word, line for line code so I can't copy it, really. I mean, it's in the name. I cannot word for word, line for line, copy the code, but I can write my own to execute the same function. And we run this all the time with AI. Now people can use AI to author things, which now is up to the courts to decide whether AI can be an author. But also, it's really easy to kind of reverse engineer a lot of, especially things like photos, code, any of these things, books and text. So going back and creating your own expression, you can make it your own, right? So this is not really going back to who had the original inventive thought, like a patent. It's going just how does this thing look? If someone who'd never seen the Mona Lisa before painted something eerily similar to the Mona Lisa, they could copyright that because they're not copying it and it's their own artistic expression. Now that would be an interesting thing. I would love to see it, but again, it's its own narrow subset of IP here. Copyright registration enforcement. You can register this federally, similar to copyrights and trademarks. It's not really a prosecution process. You just send it in, you pay your fee, and it creates a record of notice that you have this registered copyright. It helps you assert a infringement action against someone else. So benefits of talent registration are you register within roughly 3 months of publication or before infringement. It unlocks the ability to get statutory damages and attorney's fees if someone infringes, up to 150,000 per work. Obviously, this can get pretty excessive. It used to be if you put a DVD or VHS in, you saw the long, if you copy this statement beforehand, that's copyright. Notice and why to register using the C notice is good practice. So, if you do on Microsoft Word, it's the parenthesis, capital C, close parenthesis, put the copyright notice on there. You can put it on any fixed expression. So, like, technically, these slides, I could put a copyright notice on the bottom of it. I could limit the use of it and the distribution of it. And I could have, a licensing scheme where you have to pay $5 to have access to these slides. Now, we're not going to do that, but this is where things like open source licensing and things like that come up. Which is, someone has questions about those, we can talk about that as well. But traditionally, when we're doing open source licensing, whether it be for software through GitHub, pictures through like Getty Images, that's usually, a copyright. We're licensing a copyright. We're giving someone some express privileges. We have the ability to tell them not to use it, but then under a certain subset of licensing language, we're allowing them to use it, maybe distribute it, maybe modify it, depending on what bundle of rights we're giving them there. So an example I had in here was a photographer discovers her photos are being used without permission on a major website. If she never registered her images, she must register and wait for the Copyright Office to act before suing. And even then, without timely registration, she's limited to actual damages instead of statutory damages and attorney's fees. So it's how you can recoup. It's the strength of your threat, really, is what it comes down to. When you send that cease and desist letter, you can say, we have this registered with the United States Copyright Office, and it creates that much higher threshold for damages. So really, all of these things are kind of a risk management and how strong of a case can you build against someone. Often, many of these things settle or never even see a court. So it's all about building a strong brand, a strong case to protect your work and your effort and your investment. And copyright's a huge part of that. And also, not spending time and money to create things and then finding out that it's not yours is another big part of that too. So the contractor trap, I already hit on this, work for hire stuff. If you have a W-2 or payroll employee, the employer most likely owns it. It's always helpful to have agreements in place for things like that. Independent contractor, you want to have agreements for this as well, but you want to specify who's having ownership. If you are someone who's doing independent contractor type work, if you're a photographer or videographer, you're inventing or creating, fabricating, whatever for someone else, this is something that you may want to consider. Maybe they pay a higher fee to have the ownership to the work. You see this with photographers all the time. They take the watermark off if you pay a certain amount or you have an access to the original. It's through that. So this is all within the contract. And these are things that you want to specify in these things. Again, we'll send these out. You can refer these. I'm not going to get in the weeds here, but just something to keep in mind. Using others' content and AI tools, be careful. Yeah. A lot of stuff, a lot of uncertainty on AI, but it's an easy way to infringe on other folks and to maybe potentially not have a copyrightable asset. If AI makes if you make an AI image, AI is not a human physical person who can be an author to the thing. So you may be limited in what you can copyright. So if AI authors, a manual that you want to copyright and license out for your office or your employees, you likely cannot copyright that. You need some sort of human authorship. Now, where that line is currently being fleshed out. Is it just a tool being used by the artist to create the thing? TBD. But you want to have human involvement to minimize risk there. Fair use. I run this all the time in an academic context. Someone says, "Well, I cited my sources. Oh, we're good to go." And that is not. It's a case by case determination. Again, it's all upon your risk. When in doubt, ask or figure it out. But normally, you want to see the license on which you can use things. Notably absent from my IP presentation is pictures of things because I'm trying to practice what I preach here. But you want to make sure that you have fair licensing terms on what you're going to use. This happens all the time with social media and posting things and because you're putting yourself out there using other people's content. So make sure you have a license through copyright for those sorts of things. Trade secrets, I hit on these things that you keep secret. You can sue someone for stealing. Happy to go more in depth on that, but it's a more fickle beast. And then agreements are the big thing for trade secrets, right? You want to use NDAs and confidentiality clauses and employees and contractors and partners. NDAs are huge. Easy to find form ones to execute and use. Limit access and secure data. Use passwords encryption. I mean, this is where you really want to spend the extra time to make sure things are secure. Because even unintentional leaks, you could lose your trade secret protection. You can't sue someone if it's already out there. Now you can sue the person who stole it, but that's oftentimes harder to do. So, which is your only cause of action. Once it's out there, and you lose your trade secret. This is why, Coke expends a ton of money on their formula. Same with KFC. Same with large companies with certain business methods and algorithms and things like that. And educate and enforce. You want to train your team on how to use things, access. Don't log in on your wife's computer to our client CRM or client database or things like that. If you want to have some good data hygiene and to keep a trade secret. This happens quite frequently. I've done it with my UK laptop before. So key IP related agreements, employment agreements. You can have IP clauses to assign any inventions they have. This is kind of just more practical stuff here. You can just button things up, have confidentiality clauses when you're hiring folks. If you have existing employees and there's something you're worried about, let's say you're creating, IP, copyrights, trademarks, whatever it may be, brands for people. This is something you might want to look through, that your employees don't retain some sort of ownership stake in the work product they're creating for you. Contractors are a much more fickle area of this. You really want to make sure that you have agreements in place. Even if it's just a buddy doing a thing for you for free, make sure that's written down, and make sure you understand who's doing ownership, especially early on. You may have contacts you've made in your community who have skills and can help you out. Translations are a big one. A translation is a statutory work for hire, but you have to pay someone for it in order for it to be the rights to be assumed to be transferred. We run into it all the time in the UK. So either you're paying for the service, which we would still recommend having an agreement, or you have an agreement in place to make sure who owns the copyright, and the IP that's created. NDAs and partnership agreements, another thing. You can have IP clauses and assortment of things, licenses to underlying IP, assignments to future IP, things you'd want to see an attorney about. Anytime IP is going to come up in some sort of relationship with another company or a contractor, it's something that would be good to consult someone who knows a thing or two about these things, or an attorney. Would be the person who to talk to. But licenses and sales, yeah, to monetize IP. So all of these things are restrictions on someone else's ability to use your asset, right? In order to give someone else the ability to use the asset, you assign them a license. Those are contracts that you can execute with the other party. Open source licenses are the easier way to do it, which, you can Google and read up on. Plenty of folks do that. You're giving away IP rights for oftentimes no cost. So something to consider as well. But in order to give someone the ability to use your IP, you have to have a license. I run into people all the time. They want to just put something online, put something on GitHub, put something on social media and say, download this. But I mean, if I was advising someone who was going to use something that was download this, I want to make sure that there was a license accompanying it. Something that has a copyright notice on it, absent a license, you cannot use. You don't have permission to use it. So you want to see a license. You want to make sure that anything that's copyrightable, trademarked, patented is being licensed to you to use. And that's just honestly down the road. Let's say you use that product, you use that tool within your workflows or in your business. You don't want to come down and bite you down the road, or you have to go renegotiate a license on something you're using or that's critical to your process. So things to keep an eye out. I have common mistakes on here. We're hitting on things that we already hit on. You want to do a search, you want agreements, you don't want to disclose an invention too early. And don't just believe, you can mail something to yourself. There's a lot of people have tried to save money in this area. And while there are situations where maybe if you mail yourself a copy of the thing you're trying to protect, you could then in court argue that established a record due to the postmark on the mail. It's not best practice. So I would not do that. But these are all for references. We're approaching probably the Q&A section here. So we can start hitting those. And then, we'll send these out. If anyone has any questions kind of due to these cases I have here at the end that you might encounter, feel free to reach out. I'm happy to talk about this stuff. And then IP checklist here at the end. I found this just kind of organizing my thoughts of just if I'm someone who's running a small business, what are things that I can do, for my business, right? And I think these are things that are very doable that you can kind of brush up on and provide some value, if not for you, for your employer, for your business partners, whoever it may be. But easy things like website marketing and hiring and, trying to figure out what's patentable, what's not patentable, and how do we, manage that timeline are all big things, where you can provide value to whatever institution you're in. And here's just resources at the end. USPTO has a ton. They have some good resources for inventors. Louisville just opened a patent resource center through the USPTO, which is great. Good pro bono work there. So something I'd recommend for the patent side, copyrights and trademarks. The USPTO is great. The Copyright Office is great for helping people out with that. They want you to file these things, partly because they're supposed to be sustained by their own fees, but partly because it's good for economic growth, and it's huge for small businesses. So anyway, that's really all I have. We can kind of go into the questions that are in the chat, or apologies for talking so fast. There's a lot of content there.
That was fantastic, actually. And we got a ton of questions. Um, but before we jump into those questions, I do have a question. Can you just speak a little bit about the difference between a trademark or with the USPTO and the state of Kentucky has a trademark office as well, right?
Yeah, they do. Yeah, and it's thresholds of damages. So we kind of hit on that. You can sue someone just from your common law regular use of a trademark. And the federal standard is much higher. And it used to be before the internet, in order to file a federal trademark, you had to actually be in federal jurisdiction. You had to sell something over state lines, in order to have some sort of, in order to evoke the Commerce Clause of the United States Constitution. So you would file within the state of Kentucky because you're selling, you're a plumber and you want to protect your name, and you're not plumbing in Ohio or Indiana, you're just in Kentucky. So that back in the day it would not fit a federal standard. It's cheaper to do Kentucky. It's often, I mean, it's part of a checklist of things that I would look for. You definitely don't want to infringe on someone if you're going to go register a name. But yeah, it's just another form, another way to do it. You'd sue under state law versus federal law. The
Mhm.
standards might be different. I'm not someone who practices in the litigation realm all that much on enforcement, but it's just another way to protect your name and brand.
Yeah. Heather had to leave, but she had a bunch of questions. So she was curious about what happens in the 21 months period that you were talking about in the beginning. Can someone steal your idea during that period?
No, yeah, no, that's part of the first to file system. So it's all at filing date. So that's why you'd file that provisional patent application.
Hmm.
And that's part of that kind of feeling out the timeline. If you think of something cutting edge right now, we have folks at UK. It's they have an idea related to AI. It's like this is changing every day. Let's get a provisional patent application filed tomorrow or yesterday, really, and let's get our because whatever you file with the USPTO establishes a record of this was your
Yeah.
idea on this day. So with that 21 months now, and you can go back and you can sue someone once someone's on notice that you have filed a patent application. So this is why you put patent pending on your invention, right? So if someone steals the
Mm.
idea, they're on notice that you filed with the USPTO. Now
Yeah.
non-provisional patent applications publish, um, and they're available on Google Patents on the USPTO's website. Provisional patents do not. So that's up to you to put people on notice that you have a patent application filed. Yep.
Gotcha. Here's kind of a broad one. Aminata, how are you? She says, how do you protect your custom-made design clothing?
Yes, custom made design clothing. Yeah. So a couple things, and these are fun because it's a lot of ways you can do it. So a big way would be copyright the design, right? Distinct aspects of the design you can copyright pretty easily. Actual like if you have sewing patterns and things like that, you'd be able to protect those. You could license those out to someone who's manufacturing or using it. The actual trade dress, like what it looks like, we see this all the time. Louis Vuitton with their heels and the red bottoms would sue people for a trade dress aspect.
Uh, yeah.
But use and then actually like having agreements with folks. So whether it be someone you're hiring to make the goods, I would have some sort of IP assignment back to you. Hey, this IP is all these ideas are owned by me. I'm just spitballing here. It's not legal advice, but you want to have agreements in place that secure ownership with you on all these ideas. But it's brand management is really what ultimately is. You want to trademark the name, you want to build your brand, people recognize your designs to the name. A common one we see similar to fashion, and I play guitar on the side, and you see it with guitar designs. You can't patent, the curves of a Fender Stratocaster, but the molds and the way that they make them, they can enforce that against people. And the same goes for fashion. The Louboutin heels is a big one because there's been huge cases and they're really expensive. And you see those readily identifiable, like the LV on Louis Vuitton. That's a trademark, obviously, but the copyrighted, the patterns and the way the bag's designed, and the color schemes, all of that you can protect. Some of it you can register, some of it you can't. Some of it's just through actual use and adoption. You have some sort of common law protection on that. But good question.
Mhm. Yeah.
Harder, and it's through use and recognition and establishing a brand.
And this is a good point that having good legal representation and backing yourself up with people that know what's going on and where the pitfalls are is super important when you're putting stuff out like this.
Yep.
So, so here's a question that I had, and it's kind of what could happen. And I recently had someone have this happen to them, but they were doing a service and they had gotten notice from a company that they were infringing upon their patent, but this company had a patent was from 80 years ago or something like that. The actual company was defunct, and some attorney had picked it up as one of these patent trolls. How does all that work, and how do you protect yourself from that?
Yeah, if someone's putting you on notice that you're infringing, so the reason you do that is in the United States, if someone's on notice, you can sue them for triple damages if they continue to infringe. So you always want to let people know, you want to give them a chance to stop infringing. Now you can still sue for past infringement, but if someone willfully infringes, your damages, I mean, if you look at some of these patent lawsuits, the damages can be in the hundreds of millions of dollars. And normally it's because they're claiming that someone was willfully infringing. You told them you're infringing and they keep on doing it. Now, if it's 80 years old, you get 20 years, right, to have a patent. So I would first check the validity of the patent before you maybe do something else. I mean, you obviously want to probably get an attorney who knows what they're doing because these things could ruin a business due to the
Mhm.
magnitude of the lawsuit. But yeah, patent trolls exist, and a lot of it's just checking the validity of their claims, right? You would ask. I mean, you like anyone else has the ability to ask someone, "Hey, what's the patent that I'm infringing on?" and things like that. So you can get a better idea of do they have a strong claim or not? Because in many situations they don't. In many situations, they might. So yeah, ask questions, get legal representation. There's easy ones you can, we get people all the time who'll get these mailers, and since these things are public, these folks can go see on the USPTO recently granted patent applications, and they can go send you mail because they have your address and who's the applicant.
Ah,
So you can, those are more scams than patent trolls. Now there are these patent banks where they go and buy active patents and they try to sue people and try to get settlements. But the actual scams, I feel like, are far more, especially with just scams broadly due to AI and the ability to churn these things out are much more common. So I'd watch out for those sorts of things, especially the business registries. I mean, focusing on the Secretary of
yeah.
State's website, find your business, find your address, and send you mailers, and it's tough. So I would not fall victim, especially that's something also to bring up. You may get ads all the time for like get a trademark on your business name because they'll get your public
Mm.
information. If it's not an attorney or someone that's not something that's not a scam I'd play into.
All right. Um, Heather says, I'm building a new type of art museum. I'm building a franchise to establish one in each state. Where can I go for more information on how to approach this? I'm building the IP strategy now and activate the process this month. Any straight line guidance would be helpful.
Yeah, I mean a lot there, right? Like name, name would be a big thing, and actually having the IP rights to display. I'm not really big into the art industry, so obviously there'd be a copyright on the actual fixed art and things like that, and how you're using that, if you're going to try to sell it or not, and things like that. I really don't know how that works in the chain of custody side of things, but a lot of it would be brand management stuff, trademarking the name, making sure
Mm.
that you maintain usage, right? If someone's going to use the name of your gallery or put it in their ad materials, make sure that they're using it the same way. Make sure that you have the registered mark, put a TM on it before it's registered, things like that. Early on, just to assert your ownership of the brand. I would use the same style. If it's a stylized logo, don't have different styles of it. So early on, fix a brand, use that, use the same colors, do things like that. But really, for that, it's really a trademark and brand strategy more than any sort of patent or copyright or anything like that.
Yeah. Here's one from my really good friend Melissa. She says, you mentioned registering a LLC domain does not create a trademark. So if after checking USPO, state records, etc., you open an LLC with the future possibility of later building a brand or invention under that LLC, just not immediately, is it best to file a trademark sooner rather than later?
Yeah, with all these things, it's best to use it sooner than later so you can always go back and show that you're using it in commerce. So if you're performing services under the LLC or creating goods under the LLC, it's much easier to file a trademark application once you've been using it. So that's what I would say. Start using it, incorporate it. If you know it's open, now you run the risk of someone else taking it in the meantime. So that's why you'd want to do it
Mhm.
sooner than later, so you don't have that registered and someone else goes and gets out from under you. Now, you could have permissions to still use it because they came in after you, but that's not best practice, right? It can limit the
Mhm.
scope of the goods and things you could protect. And something that I didn't hit on with trademarks is the more you use it and the longer the protection you have, you can build a greater brand. So, for example, Nike, when they registered their trademark, was almost certainly Nike Athletic Shoes, their Nike Athletic Company. Over adoption and time, they're able to just use the term Nike, and they have protection over that. And the stronger the brand, the stronger you can enforce it against people. So especially on
Mm.
goods, the fashion example, the stronger brand you have, the easier you can go to customs. And if someone has counterfeits, they'll shut that down really easily. If you're one of these big brands that has built that up over time. And time is a big part of that. Brand adoption, time of registration. So if you're a newly
Mhm.
registered brand, you have less enforceability due to your market presence. So yeah. So sooner than later, all these things. Cost is the prohibitive aspect on a lot of these things, right?
Right. It's a lot of work to manage all this stuff.
Yeah.
Melissa also asked, is it best to hold patents, trademarks, et cetera, in a separate holding company, or can you just leave it under your LLC?
Yeah, best practice is, but and plenty of folks don't. And I mean, that is the beauty of an LLC is that you're already protecting yourself from liability. Yes, it gets more complex legally, is all it is. So I would do it myself. I'd hire an attorney to do it. You would have the assignments. So there's a difference between for patents, inventorship and ownership. So you would be the inventor, whoever invented would be the inventor, and it would be assigned to that entity. You would then have to have a license from that entity to your main business entity. So at UK, all our patents are assigned to the University of Kentucky Research Foundation, a separate LLC. And this is not just a recent new LLC. It's been for as long as early 1900s, I think UKRF has existed. All of our patents are held there and they're licensed to the University of Kentucky. And that's what you would do. And a lot of large companies do that. If you search for
Mhm.
patents, you'll see, Boeing Holdings will hold all their aircraft patents, and then Boeing will just actually run the operations. That protects you, I guess, in practice from large lawsuits. But again, if you're a small company, you probably don't have to worry about it. Um,
Mhm.
Best practice maybe, but maybe not worth the upfront investment to protect it, have some sort of agreement, things like that.
Yeah, there's a matter of risk, how big is the risk? And
Certainly. Yeah, it depends what area
uh,
you're in too.
yeah, Prilla asks, how do you protect your caregiver business? Kind of broad, but um,
Yeah, back to the brand thing, probably having a name for it, having recognition, having agreements. If people are going to make ad materials, marketing collateral for you, things like that, you would want to have, all of the materials are owned by you, or that they use your marks and things like that in a way that you're owning and protecting and have control over. A big part of trademark and brand protection is control. You want to exercise control over all the things that you want to
mhm,
own and assert ownership over. So if you have a caregiver business and let's say you're going into homes or institutions and things like that, and you have marketing materials and things like that, you just want to make sure that you have copyright notices on, I saw someone down here put recipes on there. You want to put copyright notices on these things so people know that you own it. You want to have the owner as the entity that you are. If you're a sole prop, then I guess it would be you. But if you're an LLC, you would have the LLC owning the copyright. So all rights reserved, Zach Stacy Enterprises. So people are on notice that you own this asset and that you exercise control over it. Same goes for trademarks, registering those, exercising control over it. Caregiving thing, I mean,
mhm.
obviously, the protection probably is less so on the IP and more so on the, care, liability, things like that.
Yeah, a couple more here. Sarah, how do you protect your recipes?
Yeah, recipes are a big one. Actually, I did a lot of research back when I was in law school because I was working for a law firm. We had a case about calzones, and someone was trying to copyright. There's an appellate lawsuit in Ohio on this calzone restaurant, and they had claimed that they had this very particular calzone, and really the court decided that there's only so many permutations of calzone, which is pretty demeaning to the calzone. I want to go try it. It was it was like a Philly cheesesteak calzone is what they were trying to go after, and that they had this recipe. So that's the big thing. You want it to be distinct. You can copyright your recipe. So it's big for like instructions, right? Like the cookbooks of old, like Martha Stewart's cookbook, where she's telling you how to do all these things and what ingredients to buy and what temperature to set your oven at. That's much easier to protect than the actual final manifestation. The Derby Pie Company is a good example. Like they own the trademark to Derby Pie. They may own the recipe. You can kind of reverse engineer it. Every restaurant in Louisville and Lexington and elsewhere, will have their May Day, race day, whatever pie. So the distinctiveness is what you can protect, the copyright for that. The instructions, you can looks and things like that, but the instructions would be the big one. And it's easier too when it's a book. It's a bunch of things, because then it's much more distinct. So that's
Yeah.
how you would do it. Copyright, put a copyright notice on it. So whatever your business would be, it'd be copyright, whatever you created it, all rights reserved, Sarah's Bakery or Sarah's Restaurant.
Mhm. One more here. I had a guy that I met, I don't know, several years ago, and he was telling me that he was working for kind of a large company, and during his breaks, he was writing a book and then he published it and it took off. And his company sued him because they said that they had partial or complete ownership of that work because he did the work during working hours and he used company equipment to do that. That's a thing, right?
Yeah. I mean, that's what happens at UK, right? And that's kind of what I was bringing up earlier about employment contracts as running a small business. Like you want to have these things worked out when you hire someone, so these aren't arguments you're having down the road. And just someone knows when they're coming in, hey, if I invent something, if I've worked with folks at a machine shop, and if someone, they have an idea, it's semi-related to a client's invention that they're making, but the client wasn't telling them to iterate upon their design, and on their own time using company resources they created a new, type of bolt for something, for a certain application. Who owns that? It's much easier to have that outlined within an employment agreement. But traditionally, if you're on company time using company resources or using information that you otherwise wouldn't have had, so we run into that all the time. If you have a client who's posting with an issue, now the info, same as an attorney, right? Like if I have a very particular, let's say Boeing is a client of mine as a patent attorney, I know their jet engines very well. I'm allowed to go work for Lockheed and use the information, the expertise I've accumulated as working in the aerospace sector, but I can't use
Mm.
Boeing's designs to go work for Lockheed. So that's where the employment thing gets a little fickle. On company time, no. Using company information, no. But using the expertise and knowledge you have working for an employer to go make a new thing, create a new thing is usually okay, unless it's explicitly forbid in the employment contract. So
Right.
more more more,
Zachary,
uh, more reason to read the stuff we all just click through.
exactly. All right. Are you in private practice also, or just specifically with UK?
Nah, just at UK.
Yeah.
Just working for folks at UK, which, to that respect, I'm always happy to hop on a call with anyone and talk about these things. Obviously not representing or just,
Yeah.
from we are funded by taxpayer dollars and government money, and we deal with folks all the time, as well as an opportunity to maybe find collaborators at UK because we do have businesses and, we're a land-grant university with, 50,000 employees. So we do have a bunch of work that may overlap with what you're doing, and it can kind of fit under our purview. So we can always put you in
Yeah.
contact with someone. But yeah, we do trainings and
But
resources, and we have things like that too. So if you have questions about things, I can maybe give you a quick answer, but also put you in contact with the right person.
yeah, what's the best way to find a patent or trademark attorney? Just other than Google, is there a good path for referrals and
Yeah, the
things that you
USPTO has a registry of them, right? If you're in Louisville, a great opportunity would be the USPTO Resource Center at I think it's at the library, at the University of
Mm.
Louisville. UK, there's been attempts. The law school is a good place to reach out to. Um, we take externs that can do some pro bono work. So I would say those are good places. The USPTO has a registry of registered patent attorneys. So you have to take a patent bar, you have to have a science background to be a patent attorney, and then there's an active registry of folks who can do patents. It's much more broad who can do trademarks and copyrights, but patents are the more restrictive ones. So that'd be an easy place to start. If you Google it, you're limited by SEO and who's paying the most to
Mhm.
be the top patent attorney in Kentucky.
Right.
But again, you can reach out to us. We have a list of folks we've worked with or that we know pretty well. It's a small network of folks who do this work in Kentucky.
Yeah.
Um, so
Zach, this has been fantastic and it's been a lot of fun. I really appreciate you coming and sharing with everybody. I know everybody really appreciate it. You got a lot of thank yous on the chat today.
awesome. Yeah. Thanks, everyone. Thanks, Dave, for having me. Thanks, Janet. I appreciate the
Yeah.
time.
Thanks everyone for joining. Thanks, Janet, for driving the ship as always.
Sure. Just a reminder, Zach will send us his presentation. We'll send that with the recording out in one email, and in another email, you also see evaluation that we'll need everybody to fill out. So look for those two things in the next couple of days. Thanks, Dave.
Yep.
Thanks, Zach.
Yeah. And thanks everybody. Thanks for joining us. We'll see you next week on another Toolkit Tuesday. Take care.